Well, thank you for joining us, and it's my pleasure to welcome Robert Lempens, a lawyer in Adelaide in South Australia, whose main practice areas are estate planning, including wills, enduring powers of attorney, and advanced care directives, as well as other matters. And Robert was a speaker at the Rainbow Rights Forum that launched the Rainbow Rights Toolkit in 2024 in Adelaide. And the kit was produced by Cota SA in partnership with the South Australian Government's Office for Ageing Well. And the kit provides information about the rights of LGBTI plus people, rainbow people, under 4 themes: overcoming discrimination, housing, health, and planning ahead. And Robert is joining us to talk about some of the key issues to do with planning ahead as a rainbow person as we age. Just a quick reminder that we are talking about South Australian law, and it may be different in other states or territories. So always get information and advice that is relevant to the place you're living in Australia or anywhere else in the world. But the Rainbow Rights Toolkit is a very good place to start if you're planning ahead and you are living in South Australia. So welcome, Robert, and thank you for joining us. Let's go to this question of safeguarding future rights that is talked about in this toolkit. Why should we all have a will, particularly if we're a rainbow person?
Well, it gives rights to your partner. So if you've died and your partner doesn't have any rights, in relation to, say, staying in the property, what will happen is that the property will be sold and your partner will be left without any ability to live in the house himself. So in our view, it's always best to have a will in place where you say, well, okay, I give my partner the right to stay in the house for 12 months, for 5 years, until he needs to move again. That way he has security to know that he will be able to live somewhere into the future.
No, or indeed you could give the house to your partner. So it's, of course, some people will be watching this who do not have a partner. It's still important, though, isn't it, to be clear who you'd like your property to go to, a house or other property, because if you die without a will, there's a system for doing it, isn't there? Could you just briefly explain that?
That's right. If you die without a will, it's called you die intestate, and that'll mean that there's a certain regime in which your property will be distributed. Now, I've had cases where people have had a far distant cousin, for example, who suddenly inherits all of his property, whereas the person's friends who've been looking after them for the last few years don't get anything in relation to that person's estate. So it can be quite distressing to friends when somebody who they haven't seen for 10 years perhaps suddenly inherits all of this money.
Let's turn to the question of marriage, now that we have marriage equality in Australia, and also registering a relationship is something you can do in South Australia. Can you just explain the difference between a marriage and registering a relationship, if there are differences?
Well, in fact, there are no real differences in South Australia between marriage and registering a relationship as far as the rainbow community is concerned. The thing to remember, though, is that if you marry or register a relationship, it will invalidate any current will. Now, what I found after that forum we had was a lot of people came up to me and said, gee, I didn't know that because we've now got married, that suddenly the will's no longer valid. So it's an idea then to review what your documents you've got.
Exactly. And of course, that's true for non-rainbow people too, that when you marry or register a relationship, you need to make a new will. And I should say to people watching this, the Rainbow Rights Toolkit, which you view online, has all these topics about planning ahead with little hyperlinks to relevant legal advice organisations in South Australia that you can go to. For example, the South Australian Health Department has a plan ahead section on their website where you can look at advanced care directives, which we'll be talking about shortly. There's links to the Legal Services Commission of South Australia, which has a whole lot of information. So the great value of this kit is it's perpetually up to date because it's putting you directly in line with the websites of the relevant organisations where you can get legal information and advice. And of course, there's always private solicitors. Just before we go on to some of the other key documents, I think another issue that was raised after the Rainbow Rights launch here in South Australia was people didn't understand the significance of changes in relation to marriage and registering a relationship and how it may affect Centrelink benefits. It's terribly important, isn't it, if we're a member of the rainbow world, to let Centrelink know our living circumstances, our partnership and relation circumstances. Can you explain that?
Yeah, that's right. Because if, for example, your partner is a very wealthy person and has a fairly good income and is in receipt of pension through a superannuation fund, of course, the domestic partner will need to declare that to Centrelink. If you don't do that and then your partner dies later on, there may well be difficulties in relation to making a claim for the superannuation. But really, people need to speak to a financial advisor in relation to those issues as it affects them, because they are all different. A lot of superannuation funds have different trust deeds, which gives rules about how and who can make a claim.
I think your view is that while we're talking about planning ahead at the moment in relation to certain legal documents, that often getting independent financial advice is as important as legal advice, and they're almost hand in glove. That's your experience as a practicing lawyer, isn't it?
That's right. It's very important that you go and speak to a financial advisor how best to put your affairs in place. Because as I said, I've seen people who have said that they're living separately, they're not living in the same house, one of the partners dies, and then suddenly trying to make a claim on the superannuation becomes very difficult because they're not perhaps classified as a dependent according to the superannuation legislation.
So that's another issue that you recommend people become familiar with. And again, there are resources on this Rainbow Rights Toolkit about the significance of whether one or other of you, if you're in a relationship, is considered a dependent. Can you give us a sense of why that's significant, maybe with a case study?
Well, we've had a few cases just recently where people have been giving different addresses as to where they live. So the address of the partner will not be the same as the address of my client. And then the partner has died, and then there's a claim made on the superannuation. Now, one of the questions superannuation funds sometimes ask is, are you living together at the time of the death of the partner? Now, if you're not living together, they may therefore see you as not being a dependent for the purposes of the legislation, and that can create problems.
Well, thank you, Robert. Let's turn to some other legal documents that are recommended for everyone, but particularly for members of the rainbow community. And one is an enduring power of attorney. And a reminder to our audience, we're talking here about South Australian law, and check in your jurisdiction to know the particularities of your situation. But here in South Australia, just a quick definition of an enduring power of attorney.
So an enduring power of attorney enables you to appoint one or more persons to look after your financial affairs. Now, the enduring power of attorney can take effect immediately once you've signed the document and once it's been accepted by the persons you're appointing, or you can hold it off until you lose your mental capacity. I normally suggest you make it immediately so you don't have to go and prove, or your attorneys don't have to prove to the various banks that, yes, you've lost capacity at the time. Now, it gives your attorneys the power to do as you say. So they have to obey what your directions are while you've got capacity. So if you want to sort of give $5,000 to the Cats Home every year, they can do so on your authority. But if you've lost capacity, they can no longer do so. They must do things in your best interests. I always suggest that people have at least two people appointed as their attorneys. That way, they both get your bank statements, they can both keep an eye on what's going on, and always be acting in your best interests.
What if someone's watching this and they're not sure if there's anyone they trust to that extent?
But I would suggest that, look, if you have problems in trusting someone, have a close look at your friends. I'd suggest get two of your friends at least to become your attorneys. That way, they'll get your bank statements every month. They can see what's going on, and it's a lot safer way of dealing with things.
And your view is do it when you're younger. Don't wait till you're necessarily, I turn 70 any minute, but you don't have to be in your 70s, 80s or 90s to do this. Why can you do it even when you're younger?
Well, you just don't know what's going to happen. I mean, you might be on that trip of a lifetime to San Francisco or wherever you want to go, and you're over there, and you suddenly need to have some contracts signed in South Australia. Perhaps you're selling a house or you're buying an investment property. Then by having somebody or some people appointed as your attorneys, you can have them appointed. They can just sign the documentation on your behalf. Also, of course, you may have a stroke or some other misadventure, which means that you've lost capacity, and then these people will be able to do it on your behalf. If you don't have an appointed power of attorney, then your relatives can make application to SACAT, to a tribunal here, to be appointed as your attorneys. Now, that may be a good thing, but it may also not be what you want. If you've had disputes in your family over the past because of your lifestyle, then you really need to think carefully about who would you want to deal with your financial affairs if you lost capacity.
Look, let's turn to advanced care directives. And again, in the Rainbow Rights Toolkits, there are a number of links that you can click and go through to, for example, the South Australian Health Department's Plan Ahead section, where there's a lot of information about advanced care directives. The Legal Services Commission of South Australia provides free advice and information. COTA SA has information. And I should say, as I indicated earlier, this Rainbow Rights Toolkit is not just about giving us information or sources of reliable advice. It's also about supporting us to action our rights. And there are links to an organisation called the Rainbow Hub South Australia, which is all about advocacy and support. There's the Rights Resource Network South Australia and a range of other national organisations. So again, I recommend the kit to you because you can go straight to the website that has information and find the organisation or the person on their phone line whom you feel comfortable dealing with. But let's come to an advanced care directive. What are they and why should we have one?
Well, the advanced care directive basically allows someone to make decisions on your behalf when you've lost capacity. So this is an issue where you can no longer make proper decisions in relation to your welfare. Now, the obvious thing is that a lot of people talk about is, well, yes, I want to. I don't want to go to a nursing home. I want to live at home for as long as possible. All of these things can be discussed with your substitute decision maker when you want to, whether you want to have the be resuscitated or not. All those things are discussed. Now, the important thing, though, is, as you said before, is that the substitute decision maker steps into your shoes. And so if it is that you have a glass of wine every night with your meal, you should be offered that when you've lost capacity as well. People may say that's not your best interest, but that's what you would have wanted to have. If you want to get your hair done every a fortnight or so, again, that is something you would have had if you had capacity. That should be offered to you if you've lost capacity. But also the important decisions about what sort of medical regime you want to have in the event that you're terminally ill.
And or even just ill. You don't have to be terminally ill with an advanced care directive. I sadly have had a very close friend contact me today just before this conversation, and who's just discovered in the last 3 days a very extensive amount of cancer, including in the brain. Now, this person may indeed discover that the treatment is effective and all is well, but once you've got something affecting the brain, it can affect this thing called capacity. Just explain that a bit more, because we've said it so often. How do you describe capacity to your clients when they ask, what does that mean?
Well, capacity is being able to understand the nature of the document that you're signing, to understand what it is you own, to understand to whom you have obligations, so to children, to your partner, and to understand what sort of treatments are wise for you in the future. Look, it is a very difficult concept to deal with at times, and we've had people who have gone into who've lost capacity because they weren't taking their medication, and then they end up in care and they take the medication and then they seem to be going all right again. So you can go in and out of capacity as well.
And that's a very important concept, particularly as you age, with things like delirium. If anyone's heard of that condition, that can be a temporary or permanent loss of cognitive capacity that can be brought on just by severe illness. But I think you've got a case study involving Rainbow people that illustrates the vital importance of an advanced care directive and filling it out comprehensively.
Yeah. I mean, I'm just not going to use their real names, of course, but I had a couple, Chris and Sam. Now, Chris was a fairly elderly gentleman, and he met Sam, who was 20 years his younger. Chris had children, and he had adult children, and seemed to be getting on quite all right as a family unit. They sort of accepted Sam with a bit of tension there at times. And then Chris was up one day on the roof, and this after they'd been together for many years, but Chris is up on the roof trying to get the leaves out of the gutter and falls off the roof onto his back, rushed off to hospital. He's lost capacity. He's lost mental capacity at that time. And what happened was the family all turned up, and Sam turned up as well at the hospital, but he was excluded from seeing Chris because the family said, no, we're not recognising this relationship. And unfortunately, therefore, Sam had to get some legal advice in order to be able to get to see Chris again. Now, had there been an advanced care directive in place, it would have been quite clear that Sam had a say in the treatment that Chris was to get, but more importantly, that he'd be able to see Chris as soon as he had gone to hospital. So it was very sad indeed there had to be this delay, and he had to take legal proceedings in order to exercise his rights to see his partner.
Look, I just want to close our conversation, I suppose, by talking about oral communication and record keeping. If I go to record keeping first, I think in the Rainbow Rights Toolkit, there is reference to the suggestion that you keep all these documents up to date and that you give, I think they say, registered copies to the key people in your life. And they mention your solicitor, your general practitioner. I would add the people that you've nominated in your documents, that it's so important to let people know that you've given them this role. Do you think that having those records clearly available to the key people is a vital next step?
Oh, look, it is. I mean, I've had a case where a man was in hospital and he'd appointed somebody to be his enduring power of attorney. So when he was in hospital, he couldn't get out of hospital. The partner went to the bank with the document and said, look, I want access to the accounts because he's now in hospital. Now, the bank was very reluctant to accept the document. They said, no, he should have come in earlier on with the document and shown us that this is what he wanted. And banks are being very cautious these days about who they will allow to operate your accounts. So my suggestion is when you've got these documents in place, just take it down to the bank, show the bank the copy. They'll scan it into their system and they'll know it's valid. The other thing to remember is that some organisations are saying, oh, if it's more than 6 months old or 12 months old, they don't recognise it anymore. I don't think that it's right for them to do that, but it just causes more difficulties at a time when you may be quite anxious about having to get funds out of a bank, and then suddenly you hit this red tape from a bank as to how to use the documentation. So my suggestion to people is normally show it to the bank, but also keep a folder with your personal papers at home where you've got copies, certified copies of all the documents. Yes, you can give it to the people you've appointed. That's not a bad idea. But I find that after 5 years or so, they don't know where they've put your documents. And that's why I say keep a copy of them with your documents in your personal papers at home.
Okay, look, thank you. And would you agree, or your thoughts on, it's very important to actually talk to people as well as doing this formal talk, but to talk to people about your preferences and your feelings and letting people know you've nominated certain people. Why is that important, that oral communication?
Well, it's if your friends and your family know what you want, it makes it a lot easier. I've had disputes with people about, which nursing home should they go into? They don't want to go to a nursing home. They're willing to spend a substantial amount of money on home care. Now, home care can be very expensive, maybe $40,000 a month having 24-hour care. But if that's what somebody wants and if they've got sufficient funds, it should be explored.
And that's a very sensitive issue if the person whom you've appointed as your substitute decision maker and can make decisions about where you're going to live, for example, if you've lost capacity, is also a beneficiary of your will, because there's a conflict of interest. Because effectively, if you're in that position where you're managing the money of someone who wants to spend many, many thousands of dollars staying at home, you're spending the inheritance of the people nominated in the will. You shouldn't think of it like that, but human beings sometimes do. Would you agree?
Well, look, you do. That's why I suggest having two persons to act as your substitute decision maker and also as your attorney. So at least there's two people giving their input in relation to what should be happening.
Just finally, what do you see as the advantage of having one place that Rainbow people in South Australia can go to get a real overview of the things that are important to think about as you age?
Well, that's the trouble, is that people, you're happily living at home, you think life is beautiful and fine, and then there's an event that occurs. Your partner gets very sick and you don't know quite what needs to happen. At least by going into the toolkit, you can see what the various questions are, and you may not even have thought about these questions, these issues that are there, about appointing someone to be able to deal with your financial affairs, deal with your health and welfare issues. So it just will give you some ideas of what you need to think about, and that's important.
Yeah, it triggers it. And I just emphasise again that in the kit there's a section right at the top. It's not a very long kit because it links you to all these other sites, but there's a quick reference guide. It has headings like, are you in a relationship? Or do you have health issues? So questions that then send you to the appropriate information that you need. But look, I want to thank Robert for his marvellous guidance to address these issues. I want to thank you for taking an interest in the Rainbow Rights Toolkit. A reminder that we're talking about South Australian law, and to follow this up for any nuances of different in the jurisdictions you may be living in. You can find the kit by Googling Rainbow Rights Toolkit. I add SA on the end, just to be clear, Rainbow Rights Toolkit, SA, and you'll see it sitting there. And please share this video to help raise awareness among the Rainbow community, particularly older people, about these issues and steps they need to take so that their wishes are complied with as they go into their later years. My name's Julia McCrossan. I look forward to seeing you at the next Rainbow Rights Toolkit video. Thank you.
This interview was recorded on the land of the Kaurna people.